And we're recording as well. Welcome everyone to this latest webinar that we've had in a series of webinars on the pandemic. We've learned a lot of lessons in the public procurement community. We've had a very successful series of webinars on the subject. We're very honored to be joined by a wonderful panel today. I'm going to be introducing them to you in just a minute. This is a joint webinar between King's College London and GW Law. And I just wanted to give Michael Bauscher a couple minutes to say hello, my colleague from King's College London. Thank you.
Thank you, Chris. Well, welcome everyone, and thank you in advance to all the panelists for what I know is going to be a great event. It's always a pleasure to welcome people to one of our joint GW King's events. We've had over the last decade or so, we've had a number of highly successful in-person events, and we're really looking forward to deepening the cooperation between our law schools in the area of public procurement. We've both got obviously considerable interest. We don't perhaps have the breadth and depth that GW does, but we do have a lot of students now, and an increasing number of students on our diploma and master's courses in public procurement. So it's an area of real priority for us. So it's a great pleasure to work together with GW on these matters. And just to say, this, to some extent, when Chris and I first talked about this was to make up for the fact that some of you will have been planning to come to see us all in March when we were supposed to be having, I can't remember what number of GW KCL colloquium it would have been, but unfortunately that was timed exactly at the unfortunate point where travel was closing down, but we hadn't all got used to Zoom events yet. So this is a sort of part payment back for having had to put that event off, and we're hoping, well, we are planning to redo the event that would have been March 2020 and March 2021, either physically or online. And I do hope that all of you joining us today will at some point be able to join us at King's for one of these events in person when that becomes possible. So you'll be able to gaze over Somerset House and the beautiful surroundings that we have, and you'll be able to do a bit better than the little architectural model that I have of Somerset House over my left-hand corner, which is a poor substitute for looking over what would otherwise be, I think, probably about this time of year, the ice rink would just be going up, so you could be waiting for some ice skating after this event. So without more ado, back to the substance. Back to Chris for managing what's going to be a great event. Thank you very much, Chris.
Thank you, Michael. And just to follow up on what Michael was saying, the information on the March event, the March 2021 event, is up on the blog at publicprocurementinternational.com. It's in the menu, and if you'd like to see what that March 2021 event will be, it's going to be focusing on contract administration, an issue we'll be taking up today. We have today registrants from over 350 registrants from over 30 countries around the world. We're really honored to have such a broad audience. And as I hope you see today, a lot of the issues that we'll be discussing, the issues that we'll be focusing on, are ones that are going to be taken up by researchers and academics and lawyers and officials all over the world. We're going to have introductions first, and we'll have presentations, and we'll have a question and answer session at the end. During the course of the session, if there is a Q&A function built into Zoom, it doesn't work as well as the chat. If you could put questions up into the chat, we'll be responding to questions during the course of the presentations, and some of the questions we'll reserve for the Q&A section at the end. But if you could use the chat function, that would be great. This is in memoriam of in remembrance of our colleague Fred Lees. Fred Lees was the professor whose place I took at GW, and Fred passed as part of the pandemic. We recall Fred so that we remember why we're doing what we're doing today. So our colleagues today who are joining us in the panel are Shope Williams-Legbe from Stellenbosch University, and Geo Quignon from Stellenbosch as well. They're going to be talking about emergency contracting and anti-corruption. And I want to stress here that these topics that we'll be covering here today, these are key topics that are likely to be the focus of academic and official inquiry over the next few years. Really, the pandemic has accelerated the study of these topics. And as you saw from the breadth of interest in this program, the pandemic has made it possible, oddly, has made it possible for us to share lessons more rapidly about these topics. Francois Lichea from the University of Lyon and Luke Butler from the University of Nottingham will be talking about contract administration issues. The European Union is on the cusp of assessing contract administration as an area of normalization, of potential standardization across the European Union. We in the United States have a strongly harmonized system of contract administration in the federal government. And I think this is going to be an exciting new issue for the European Union. And we're very much looking forward to the comments from Francois and from Luke. Gianluigi Albano will be talking to us about supply chain resilience from the perspective of someone who works at the Centralized Purchasing Agency and Rome concept. He's also a professor at Louis University. Supply chain resilience really isn't something we've talked about in the public procurement world at all. And suddenly with the pandemic, it's become a very critical topic. One of the topics in supply chain resilience is something that Jane Jenkins and Kate Goff will be talking about. They'll be talking, they're both lawyers at Freshfields, and they'll be talking about how risk allocation works to improve supply chain resilience. And that's something that I hope we can pick up in the question and answer session at the end as well. Claire Fitzgerald and Rory McDonald are part of an important project at the University of Oxford to improve government functions. They'll be talking about issues of social contracting. And here, something I want to stress, and it's important and it's a subtle point. There are issues in social contracting, the social services contracting that was being done and how the UK government flexed to deal with social contracting. It really is a halfway point between traditional procurement and then the question of how we use procurement as a fiscal stimulus or as a health measure during the course of a crisis like this one. Social contracting is right in the middle. It's a bridge between those two worlds. And I think their presentation you'll find is very, very interesting. Lindsay Marchessault is from the Open Contracting Partnership. She's joined by Nico Panagos, and they will be talking about open data, which of course the Open Contracting Partnership is focusing on. They'll also illustrate how they were able to use open contracting standards to assess ultimately, and also some hard work by researchers in many countries around the world to assess 1.35 million contracts. 1.35 million contracts. They're going to be talking about some of the lessons learned from that very intensive and very productive study. We're also joined by Mark Cheeseman from the Cabinet Office in the UK. He'll be talking about anti-fraud efforts. And in the resources at the back, we've included the OCP, the Open Contracting Partnership Report, and the report from the Cabinet Office. The anti-fraud report is very important because it lays out important lessons learned on how to deal with fraud in the course of a pandemic. It also, we'll be talking about this during the discussion, it lays out ways that you do not want to address fraud in a pandemic. It lays out some basic lessons that have emerged, and I think we're going to find that as a community a very interesting discussion. With that, I'll turn it over to Geo and to Shope.
Thank you very much, Chris. I will kick off and then Shope will follow me. So as background, South Africa is a highly decentralized procurement system with each department at all three levels of government, at each public entity managing its own procurement within its own SCM policy, but within a broad statutory framework. And in response to COVID, the South African National Treasury issued a number of instructions to all entities which are legally binding. And between 19 March and 1 September, we've had 4 distinct sets of rules instructing entities on how to procure for the pandemic, with smaller adjustments in between. Now, these instruments focused exclusively on the acquisition process with negligible attention to existing contracts or contract management or administration. And they took procurement practices quite far from the standard practice, although largely within our existing legal framework. At their core, these instructions did 3 things. They increased reliance on centralization, they mandated the blanket use of emergency procurement rules, and they attempted price controls. And in my view, none of these were particularly successful. The increased centralization mostly involved allowing all entities to buy from what is locally known as transversal contracts. These are contracts arranged by the Treasury for the supply to multiple public entities. Many urgently required items, mostly PPEs, were already being procured by multiple entities under existing transversals. And these are typically in the form of framework agreements. The special instructions allowed any entity, even though it didn't form part of the original participating entities list, to join the contracts and thus to acquire under the transversal. Secondly, Treasury obtained quotations from numerous suppliers for items not covered by existing transversals and made those quotes available to all public entities so that they could acquire the goods via the quotation, the closed quotation system, without having to obtain quotes individually. The immediate centralization of procurement in the face of an inherently decentralized system resulted in significant relaxation of standard control mechanisms, which ostensibly led to extensive abuse. The existing emergency procurement rules were largely relied upon for items that were not covered by centralized mechanisms. And these rules allow entities to procure using any method, which in practice means by way of direct contracting in case of emergency. The key control here is that the accounting officer must satisfy him or herself that, on objective grounds, an emergency situation exists which renders it impractical to follow the normal procurement methods. The Special Treasury instructions deemed all COVID procurement as qualifying for emergency procurement, thus removing the individual determination requirement, and which again opened the door to significant abuse. And thirdly, Treasury attempted to implement strict price controls over various items and primarily again PPEs. The special instructions contained lists of maximum prices that entities were allowed to pay regardless of the procurement method used. And again, subsequent evidence has shown that these measures were ineffective, which I think is hardly surprising given the reality of the surge in demand. I think that there are a number of lessons to be drawn from the approach adopted in South Africa. Firstly, the existing emergency procurement rules are simply inadequate and abandon standard controls to an extent that I don't think is justifiable in a context where integrity in the procurement system is already low. The challenge, though, is to work out how to achieve an adjusted balance between efficiency and integrity in such a context of urgency. The South African experience suggests that we didn't get that balance right. Secondly, and perhaps more interestingly, given that we are heading towards major procurement law reform here, the simmering pre-existing tension between centralization and decentralization of the procurement function has really come to the fore. In a public finance system squarely premised on devolved spending power and responsibility, a need for high levels of coordination and cooperation in procurement is not easily achieved. In South Africa, at least, I think that much more attention must be given to ways of achieving such coordination if the paradigm of devolved public finance management is to be retained. The powers of a central procurement structure, for example, within National Treasury, as was the case during COVID, vis-a-vis individual departments and entities that largely control their own budgets, is a major issue in procurement regulatory design here. I don't think, however, that greater coordination through centralization in the architecture of the procurement system is necessarily at odds with a devolved institutional design of public finance management. I think one can have a significant centrally steered procurement system while retaining public entities' financial autonomy. But this requires one to separate the procurement system from the larger public management architecture, which I don't think is readily appreciated in South Africa. And with that, I'll hand over to my colleague to discuss the consequences of these practices. Over to you, Shope.
Thank you, colleagues. Thank you here, and thank you to GWU and King's College for putting this on and for inviting me. I'm certainly looking forward to hearing what lessons we can learn from other jurisdictions. So to pick off from where Hugh left off, I just want to headline some of the issues that we've had around consequences, what we've seen, and in a way, what the future portends in relation to the pandemic procurement in South Africa and procurement more generally, really. Of course, all countries are still addressing this pandemic, so it's hoped that we can learn the lessons and really improve even as we continue in this global problem. So in SA, as in everywhere else, in South Africa as in everywhere else, we've had a lot of pandemic procurement corruption, and this has taken the form of procurement fraud, bribery, conflicts of interest, contracts going to politically connected persons, payments for goods that were never delivered, payments to suppliers who didn't even have contracts with the government. And in the early days, it really, it looked more like a feeding frenzy because of the lack of controls that Hugh talked about than an attempt to actually get goods for an emergency. The good news, if you can call it that, is that it seems like there will be some form of holding to account for the persons involved in COVID related corruption. And we have a name for the people who exploited the pandemic. We call them here COVIDpreneurs. So you can tell that to Merriam-Webster. So anyway, since July, we've had about 900, just over 900 firms and individuals who are under investigation in relation to just over 1,200 contracts, and 34 of these people are currently being prosecuted in court. And so what's interesting is that these crimes are being tried in what we call our specialized commercial crimes courts. And these are courts that were set up in the late 90s to prosecute commercial crimes like fraud, corruption, bribery, money laundering, etc. These courts have functioned quite well, and they actually have a 90% conviction rate. And just 2 days ago, on the 28th of October, our president announced that they would actually create 5 more divisions of this court to enable the fast prosecution of COVIDpreneurs in other provinces in South Africa. So it looks like for the first time, we'll be seeing contractors that abuse the system being held to account. We already have a precedent for convicting public officials in relation to procurement corruption. Not often, but it's happened. And last year, we had a case where a local government manager, people we call municipal managers, was convicted for the unlawful use of our deviation regulations, which Hugh has talked about, which permit the use of sole sourcing procurement in sole sourcing procedures in emergencies. And in this particular case, this municipal manager was convicted for 2 years jail time of failing to take reasonable steps to prevent the irregular expenditure that arose from irregular procurements because they abused the deviation regulations. Even though the municipal manager himself was not guilty of any allegations of personal corruption or fraud in relation to those contracts. So basically, we're expecting to see a lot of prosecution and convictions of both the public and private sector participants that are engaged in COVID corruption this time around. The other thing that we've seen in response to the COVID corruption was that the government ordered the publication of all contracts that were awarded under the emergency regulations. And I think that was done in August. So these lists of these contracts are available on our National Treasury's website. And it's a first, and it starts the conversation that we need to have over the publication and the transparency of government contract data. In terms of future initiatives, even though the government has made these strides in relation to investigations and prosecutions and publication, there's still a lot of gaps. So for instance, the contract data, the emergency contract data that was published does not provide the specific information that could actually be useful in tracking government spending. So I think that the future conversations that we need to be having as a country are whether we want to actually commit to the real publication of open data in a format that complies with international standards. And I think our colleagues from the Open Contracting Partnership will talk to us about that. And not really just a PDF list of names and amounts received, which is not disaggregated in any way. So that's the first thing. The second conversation, which I think flows from that and which I think is more interesting to me, is whether we believe that obtaining and publishing beneficial ownership information is important. I think that given the amount of given the high number of public officials and politicians who benefited from pandemic procurement, and some of which may be too highly placed to actually be held to account, I think that beneficial ownership will provide an obstacle to these people who abuse our procurement system in this way, and will assist civil society to actually understand some of these connections that are very opaque and murky now. So I think beneficial ownership will assist us to understand who ultimately has the right to own and control a firm, and who are the people that really benefit from public contracts. So some of the information that, if we take these conversations further, we'll be looking not just at what we normally have now, names of directors, but we'll be looking at details of individual owners, details of any related entity, breakdown of shareholding, voting rights, even that are attached to different share classes, et cetera. Of course, this information in all countries is not located in any one place. So collation is a big issue. And in some firms, ownership or control can be managed through trust or contracts, which are difficult to capture. Now, of course, because of the EU anti-money laundering directive, many European companies have had to implement beneficial ownership registers in order to comply with the directive. But I think that for us in South Africa, the bottom line is that we need to be able to see who the beneficiaries of public contracts are, and beneficial ownership is one way of getting there. And I think that the last thing that the last conversation, which I think we need to have, given what has happened now, is that we need to, which is a conversation which is in a sense is already ongoing, is whether we can commit to the use of better technology in public procurement, which can help with the two issues I've highlighted in terms of transparency of contract data and beneficial ownership. And I think better technology and increasing reliance of technology, moving us away from the manual paper-based systems that we use now, will also minimize our reliance on whistleblowers for uncovering procurement corruption. This conversation, I think, is actually harder because there's so many people who benefit from our manual and paper-based systems. But I think that the environment is ripe for a sustained demand from citizens on this issue. So I think I'll stop there. And thank you for listening.
Okay, thanks, Chris. So we're ready to begin. Wonderful. Well, I'd like to extend my thanks to George Washington and KCL for the invitation to speak, and I also express thanks on behalf of Francois. How do you manage and administer contracts awarded or modified in response to COVID-19? It's obviously a minefield that we'll only begin to cover in 10 minutes. We focus exclusively on the processes for determining the recoverability of costs given the high prices paid during the pandemic. Before discussing the problems of how to recover and what to recover, we wanted to say a quick word about the impact of the contract type on the question of recoverability. So as you may know, on complex contracts, a contracting authority may choose a contract type according to the risk that it wishes to bear. So to give two examples, one contract is where the contractor bears the most risk. An example is a firm or fixed price contract. Here, the contract price is based on estimated costs. If following performance, the contractor's actual costs are higher than estimated, their profit is correspondingly reduced. Whereas by contrast, a contract where the contracting authority bears the most risk is a cost plus contract. Under this type of contract, the contracting authority will pay a baseline cost, but will also pay whatever costs the actual costs that the contractor incurs plus a profit. So the contracting authority bears the risk for any last minute cost increases in that instance. So the type of contract will impact on who bears the risk for what is recoverable. Now, I just make a couple of very brief observations. Firstly, there's little evidence of what types of contract have actually been used during the pandemic, but anecdotal evidence suggests that a number of cost plus contracts have been used more than previously to enable contracting authorities to shoulder any potential exposure to cost risk, and think tanks have similarly advocated their use for this purpose. But interestingly, before the pandemic, these types of contracts were increasingly discouraged, not least because contracting authorities bore too much risk and contractors had an incentive to rip them off. So I suspect that a problem going forward will be ultimately how to structure risk under these contracts so that they don't effectively become cost plus by the back door. Francois may want to elaborate on any of the points I've made there.
Yeah, thank you very much, Luc. A few words about the French approach to this regard. Basically, public procurement contracts are in France set up on a fixed firm price model with just sometime clause about revisable price, just to take into account economic variations like raw materials price. But of course, this doesn't apply with the pandemic. So what we've been seeing is that the doors closed were not very useful during the pandemic. The other side of this public procurement is PPP's contract, which is usually based on the more sharing of the risk of force majeure, and therefore for PPP's contract you may have some examples of sharing costs. But whether you talk about when you talk about the type of price, of course, it means that you may end up with the risk of the pandemic and the additional cost which is due to be borne by the contractor. So maybe we can move on the question of standard clauses. If you wish, Luc, maybe I can keep the floor for a while and give you the floor afterwards. Regarding standard clauses, maybe it's worth noticing that, as Chris said, there are no EU contract administration directive. Of course, we may think it may happen, but I'm quite skeptical about it. I don't know whether you can see on my back the country which is in my back, which is Brazil, which has more similarities with France than any other European countries regarding contract administration and the performance of contracts. So we're quite far from having it, I think. Just to remind that there's a nonetheless on the award of the current existing EU directive, there are nonetheless some provisions regarding the modification of a contract, of course, as you may know, especially Article 72 of the 2014-24 directive. But when you think about it regarding the pandemic, obviously, these are not real constraints, since there are possibility of important modification through the unforeseeable event clause. So when you talk about standard clauses, it's really open to the different countries. In France, we have some standard clauses regarding public procurement contract, not for concession contract, but just for public procurement contract. But regarding force majeure clause, it is not very helpful since the standard clause only allow for indemnification for damages on equipment, that is to say, basically like storms on public work contracts, and therefore it was not very helpful regarding who should bear the additional cost, and the only impact it has, the force majeure clause, is that it may allow some delay for the performance of the contract. So we'll see afterwards then how to recover the additional clause. But basically, which is quite striking, is that there are no real use of standard clauses regarding this pandemic. Luc, over to you.
Okay, thanks, Francois. So if I had some of my own observations clarifying the position in the UK, in the UK at least, there's nothing equivalent to the US federal acquisition regulations that provide statutory clauses that otherwise allocate responsibility and permit recovery for things like excusable or compensable delays resulting from unforeseen events. So in the UK, there are some standard contract clauses for certain sectors, for example, defence. These do identify force majeure and other frustrating events. But generally, hopefully Jane and Kate will discuss, UK government policy doesn't treat COVID as a frustrating event generally. Therefore, unless model clauses have been developed by sector, you're guided mainly by the terms of the contract on issues such as contract continuation and cost recovery. And then that brings you to the major problem of what sort of costs will be recoverable under any contract and how will you determine recoverability under the contract. So there are two phases that you'd consider. At the contract award stage, for example, in the United States, again, the US federal acquisition regulations may require the contract officer to undertake price and cost analysis. and this may include a determination of whether costs are allocable and reasonable, for example. By contrast, in the United Kingdom, with the exception of one specific regime under the UK single source contract regulations for defence contracts, there are no express legal requirements on contracting authorities regarding their assessment of the reasonableness of costs or price generally. There is a UK open, or was a UK open book contract management policy that has encouraged recovery of allowable costs, to use that term, for service contracts, but it's not widely used. So there are problems at the award stage about how you verify prices, at least as it should be guided by regulation. And perhaps unhelpfully, the UK public procurement policy notes simply say, or rather remind contracting authorities to avoid paying abnormally high prices, but don't say much else. So there's the issue of how you determine prices at the award stage. Further, once on contract, questions then arise about whether it's possible to recover for costs that are affected by COVID-19 during contract performance. So to deal with this problem, there are various mechanisms that might be in place. There could be a change of law clause in the contract permitting recovery because there have been legislative and policy changes resulting from COVID. Otherwise, if the terms of the contract are silent or otherwise ambiguous, then the contracting authority may have little practical choice but to pay up. Now, that raises the question of what sort of costs you should pay for. You may expect to pay additional costs where you have to rely, for example, on more agency staff because a number of your permanent staff are off sick, for example, for COVID or other health-related reasons caused by the pandemic. But should recovery extend to things like costs you might expect a business to otherwise bear as part of their operational costs, for example, in setting up computer equipment to work from home remotely? Are those the sorts of costs that the contracting authority should bear? Again, there are no easy answers in the contract necessarily, and it might be questioned whether it's enough for government policy to simply say, find commercial solutions between yourselves as parties. Finally, there is the wider problem of actually verifying any costs that are claimed. In the UK, at least, there's been a drive to encourage the use of open book contracting, requiring contractors to provide pricing records and other information. That's good in theory, but the problem is that contractors may be reluctant to give that information, especially now, given insolvency risks. That information is becoming increasingly sensitive. It might also be questioned whether contracting authorities actually have the resources or time to undertake the kinds of audit and oversight functions that the government might suggest it should. So an open question remains the extent to which these sorts of techniques are actually going to prove to be useful in facilitating the recovery of costs. And I think that's all I want to say about the minefield that is contract administration. Thank you.
Yeah, thanks, Luc. I may add some point on the French law approach, which is that the government issued an ordinance on the 25th of March, trying to minimize the impact of the crisis on public contracts. But these ordinances were basically set up to allow delay in the performance of the contract, and nothing was said about the question of who should bear the additional cost, and therefore we turn to either the clauses, but as I said, they were not very helpful, and so to a specific theory which was set up by the French case law a century ago, which calls imprévision, which basically allow the contractor to have indemnification of additional cost, but only if the unforeseeable event is that important that the contract is compromised. So basically, the financial aspect of the contract are compromised, and therefore the problem with this theory is that the condition set up by the case law is not very clear-cut, and therefore there are some ambiguities regarding the use of this theory, because you need to reach a certain amount of additional costs, which is not clearly set up in the case law. So what we've been seeing is that we've been having a guidance from the government, but which only regards the ministries. And this guidance is really helpful in the sense that it encourages contracting authority to take up some of the expenses, and there's also some guidance about how to verify the additional cost. That's very helpful, but it's only towards the ministries. And therefore, what we've been seeing in practice is that there are a huge variety of situations with the state being really willing to take up some of these additional costs, whereas for other contracting authorities, the contractor end up with nothing to be taken up by the contracting authorities, and that it all lies on the shoulder of the contractor. And of course, this raised some concern. There are some kind of litigation going on, and which brings me to the conclusion, which is to say, is it really something that have to be dealt with by usual means? I mean, usual legal means. With such a crisis, can we still think as we used to think, looking at the clauses, or do we need to have a government or legislator setting up special rules regarding public contracts? It's basically my views on this point is that the classical legal means are not really adapted for such a crisis. But I'll be happy to discuss this later on if you wish. I think we're running out of time. So thank you for your attention, and I'm staying online.
Thank you. Thank you, Francois. Gianluigi?
Okay, thank you, Chris. Thank you, everybody. I think I'll try to get some time back. I want to make only 3 very concise points about this. First point is, given the set of, I would say, the legal architecture that was available during the pandemic, a lot in terms of outcomes, a lot of differences and varieties of outcomes around the world was due to different organizational models. I mean, and I want to make a point to sort of say that, given what Gio said about the experience in South Africa, in Italy, in fact, the outcome seems to me quite the opposite. If there is something that went wrong during especially the first 6 months of the pandemic, and here I'm not talking, please, I apologize, I'm not taking any view about civil works. I'm really focusing about the procurement aspect concerning PPEs, ventilator, medical equipment. So the emergency items that were needed in order to face the most dramatic effects of the pandemic. And when we look at our experience, one of the major drawbacks, and I would say the bad outcome, was generated exactly by the fact that the chaos that we observed was in a way created by the hundreds, if not thousands, of buyers rushing and desperately to put their hands on masks and ventilators, disregarding completely that we were living in circumstances under which the buying side was losing bargaining power. If you couple this with the global supply chain disruption, these effect, which is a combined effect of buyers' miscoordination and the abuse of exceptions like advance payment, single source, so on and so forth, all that together gave rise to, for instance, a high price volatility. And so we started thinking in terms of, are we paying too high prices, all discussion about price gouging, so on and so forth. And so the counter reaction of policymakers were to say, oh, let's put a ceiling on prices. So let's basically cope with an abnormal circumstance with another abnormal instrument, which is to impose a maximum prices given supply chain and supply disruption, combined. So the point is that we would have benefited from a much higher degree of buyer coordination. When I say that, I'm not necessarily saying there should be only one buyer, only one centralized procurement agency acting, but at least coordinating needs, sending signals to the market that was exactly the foreseen demand for some months to come. And by doing so, we would have avoided, and I'm pretty sure of that, the emergence, the mushrooming of intermediaries with marquee performance, or past or CV, or intermediaries coming from other fields entering the world of the PPEs just because there were huge, and I would say juicy profits to be taken because buyers were willing to pay any price to get their hands on those items. So all these price volatility, the emergence of intermediation, which is very unhealthy, was due to me, at least from the Italian perspective, to the fact that hysterical reaction from the buying side led to the emergence of an extra layer of intermediation between producers and buyers. Now, this is one thing. The second thing is, well, did we have exactly the tools that we needed in order to cope with the pandemic in terms of, procurement-wise? The point is no. I mean, framework agreements are tools which are, if well designed, obviously, they are instrumental to reach good outcomes under normal circumstances. But obviously, framework agreements hinge on the assumption that there is a healthy and normal state of supply chain. When supply chain gets disrupted, there is absolutely no framework agreement that can save your life. That's the point. The only solution is to get to have a unique purchasing and unique negotiating side able to enter into a deal directly with producers. And to me, if I look, for instance, I went through very recently to a report produced for the Assemblée Nationale in France, for the parliament in France. And when you look at prices, when you look at what France did, which is to some extent extreme form of centralization, if you look at prices that the French government was able to pay for FFP2 masks, which are by far the most looked for, at least during the first 3 months, and yet they were able to pay 1.4 euros compared to prices that I've seen all around Europe approximating 10, 15 euros. I mean, and obviously I don't want to say that it's the only explanation, but I want to say that the fact of leaving these different layers of government alone in a position to use public money, and because they were entitled to use public money, they did use public money to chaotically enter the market. And so they basically was one of the sources of the outcomes that we've been observing for 6 months. Now, the last point I want to make is about fraud. Now, a centralized procurement agency normally is not in a good position to assess qualities very quickly, and especially when those items are stored in other countries. But what we did, and this is something that we learned, and I want to repeat, I've already made this point several times, but I think this is really something that we learned, is that under abnormal or emergency circumstances, there are different parts of the public sector that could join their forces and enhance each other or strengthen the ability of a procurement process to achieve exactly those outcomes. What we did was to strike a deal with the Italian custom duties. The Italian custom duty has access to an international network, so we were able to basically look at and to assess quality of PPEs when they were stored in warehouses in Latin America, in China, in Far East, even before any penny was paid to those intermediaries. And thanks to this, we were able to basically to get our hands on tens of very suspicious intermediates, they're being prosecuted right now. We did that, and we were not able to basically get rid of all the problems 100%, but we were able to at least to intercept 90% of them, thanks to a sort of, I would say, completely new designed cooperation within the public sector. And I'll stop here, Chris. Thank you.
Thank you very much, Gianluigi. Jane and Kate.
Hi, thank you. And thank you to George Washington and King's College, to Chris and Michael for the invitation to speak. We're very pleased to join you. By way of high-level overview of the UK government approach to procurement during the pandemic, the Cabinet Office reacted rapidly to the effect of the pandemic by issuing guidance on the 19th of March. And this was directed to all contracting authorities to secure payment to their suppliers at risk of insolvency under all goods, services and works contracts across all sectors, with a view to ensuring service continuity, not just during the pandemic, but also after the outbreak, so as to preserve the supply chain. And further guidance followed in June to update and build on the first, and that applies until the end of this month, and so until tomorrow. And specific guidance was issued directed at defence, the NHS and PFI contracts. Interestingly, nothing has been published to continue beyond tomorrow. The relevant government page, website, last updated on the 16th of October, says that contracting authorities should immediately work with their suppliers to develop a transition plan to be implemented as soon as possible and completed before the 31st of October. Now, given the alarming rate of infection and demands to extend the local lockdown in the north of England to a national lockdown, it may well be that further guidance is going to be necessary to address a second national crisis. Now, interestingly, this guidance is not legally binding, but it's advisory only. But the language used is directive. All contracting authorities should, etc. Essentially, the objective was to protect against insolvency, protect jobs, and ensure continuity of essential services to the public sector. And these objectives override strict application of the contractual terms. For example, the guidance is that payments should continue based on past performance over a rolling 3-month period, as opposed to payment on a decreasing scale as a result of force majeure or reduced performance. Now, interestingly, in the context of PFI contracts, the guidance expressly stated that the pandemic does not constitute force majeure under the standard PFI contracts, which is correct because it's a very limited definition. And I will discuss more generally the challenges in claiming force majeure relief under English law in a moment. But first, the guidance. So the 19th of March procurement policy note was issued by the Cabinet Office. And this, as I say, was directed at all contracting authorities. And it required them to urgently review their contract portfolios and inform suppliers that they believed were at risk that they would continue to be paid as normal until at least the 30th of June, obviously trying to avoid job cuts. They were also required to put in place the most appropriate payment measures to support supplier cash flow, forward ordering, payment in advance, interim payments, payment on order and not receipt. And they had to ensure that they paid immediately invoices submitted by suppliers with reconciliation taking place in slower time, again to maintain cash flow and protect jobs, expressly to protect jobs. But the quid pro quo is that suppliers had to agree to act on an open book basis and make cost data available to the contracting authorities. They had to continue to pay their employees and flow down payments to their subcontractors. The guidance favoured contracting authorities granting relief against current contractual terms, for instance, flexing key performance indicators and service credits, as opposed to accepting claims for other forms of contractual relief, such as force majeure. The next guidance was issued in June, and this was entitled Recovery and Transition from COVID-19. It built on the previous provisions, It encouraged contracting authorities to review their contract portfolio and, if appropriate, to maintain delivery of critical services, to continue or commence measures in line with the earlier guidance. They were to work in partnership with their suppliers to develop transition plans to exit from relief as soon as reasonably possible. And this was obviously in the expectation that the risks would recede, as they did to a degree over the summer. But now, of course, we are plunging back towards a potential for national lockdown. Interestingly, the defence sector issued a separate, so the MOD issued separate guidance on the 20th of March, expressly superseding the Cabinet Office guidance. And while it substantially repeated the requirements to pay suppliers at risk, it did stiffen the guidance in relation to making payments. They shouldn't be made to suppliers where there's no volume commitment to supply. Payments should be carefully considered where suppliers were already underperforming and subject to an improvement plan. And suppliers shouldn't expect to make profits on elements of a contract which were undelivered. And all suppliers are expected to act with integrity, and contracting authorities will take action to recover payments from those taking undue advantage or failing in their duty to act transparently and with integrity. Again, the point was made that contracting authorities are not bound to accept force majeure claims or claims for frustration, but instead should maximise commercial flexibilities within the contract, pursuant to change provisions to agree new measures in relation to meeting lead times, revising milestones and delivery dates, and waiving or delaying existing rights, and remedies to deduct, for example, liquidated damages. What about PFI contracts? Well, in April, the Infrastructure and Projects Authority issued guidance on supporting vital service provision. And the guidance note contained 4 key messages. PFI contractors should essentially consider themselves to be part of the public sector. And it was stated that the emergency is not a force majeure event, but rather contracting authorities should work closely with PFI contractors to ensure contingency plans are up to date, to ensure a continuity of service, and all available options under the contract should be used during the emergency period, maintaining unitary charge payments, revising contractual requirements and standards, and moderating performance mechanism regimes where appropriate. So a pro-contractor, pro-supplier approach. So what's the reality of the contractual position? Well, we have seen anecdotally that parties have sought to work collaboratively. In other words, the spirit of the guidance has been followed to a large extent. It's going to be interesting to see whether that remains the case in the second wave. And of course, certainly what we have seen is that our clients on both sides of the public and private sector have been addressing and documenting claims, but have managed to negotiate those through into settlements. It is a question whether that will remain the case going forward. Force majeure, as Luke mentioned, is not a panacea under English law. It's a defence only to relief from liability. Unlike the US position under the Pfi Contracts, it doesn't result in an equitable adjustment of payments, not unless there is an express provision. And there are challenging hurdles for claimants to jump. They have to establish that there is an event of force majeure within the limit of the definition. And in the 2017, the MOD commercial policy statement provided that pandemics, such as swine flu, are not force majeure events. It's the responsibility of the contractor to ensure they have business continuity plans to mitigate such risks. Demonstrating causation is challenging. You have to demonstrate that what is the proximate cause of inability to perform is the force majeure event and not some other event or circumstance. They have to show that the event is beyond their reasonable control and that no reasonable steps could have been taken to overcome the event or its consequences. So there were no workaround measures. There were no alternative sources of staff or equipment. And then you have to comply with notices and provisions of particulars. So I'm going to pause there and hand over to Kate, but it will be interesting to see just whether there are more aggressive approaches to the pursuit of claims and whether the approach of the public sector changes going forward.
Thank you, Jane. I'm aware that we are running over time quite a bit, so I will speak very briefly. I am going to talk about some of the practical workarounds that we've seen suppliers and the UK government taking, and then just pose some questions about what's next. I've seen in a lot of the comments in the chat that have been coming up, there's been a real focus on procurement and supply of the vaccine and what lessons we can learn that can be built into that across the world. So if you think about practical workarounds, as has already been highlighted, the UK government sought to rely on the flexibilities available to it under the procurement directives to award contracts to meet its urgent needs in the context of the pandemic, and it didn't bring in any specific additional legislation. And in practice, we have seen wide use of these flexibilities as a workaround for the UK government when seeking to ensure resilience in its supply chain in the face of obviously incredibly challenging circumstances and of course unprecedented demand. For example, we've seen extensive use of existing government frameworks to award contracts to the UK government's existing suppliers, and that's been both in the context of new demand, so kind of the PPE type demand that we've been talking about, and services in the context of the pandemic, but also to cover the work scope of contractors in the supply chain who are no longer able to meet the obligations. And I think, as Gianluigi mentioned, however, framework agreements are not a complete answer. So there's been a significant increase in the use of direct awards. So one thing that I think has been really interesting is that you might have thought that this would lead to an over-reliance on the existing suppliers, leading to further pressure on the UK government supply chain, and also significant potential exposure to insolvency risk and risk of poor performance due to the kind of challenging circumstances. That actually hasn't necessarily been the case. We've seen a clear diversification of the UK government supply chain, particularly in relation to specific COVID-19 related contracts. In June, the Tussell Trust reported that nearly a quarter of the COVID-19 contracts awarded up to that point, worth in excess of 200 billion, were awarded to economic operators who had not previously carried out public contracts. Gianluigi talked about the increased use of intermediaries, and that's a concern, I think, across the board. I think in the UK, there's also been a significant criticism of the lack of experience and expertise of these new market entrants. So it might be kind of appear good from the outside that we are not relying on one or two suppliers, but in fact, the type and nature of the new market entrants has not led to real resilience throughout the UK supply chain. There's also been some focus on prime subcontractors, and I'm going to not cover that given the time. But what's interesting, I think, is that we have seen the government's key and prime contractors working really closely with the government to find commercial and practical solutions. But it raises the question about, will that continue now we have a significant second wave of COVID in the UK, and also when we are coming up against the end of the Brexit transition period, and we seem to be looking like we won't have a comprehensive free trade agreement. So my final point is I wanted to ask the question, well, what next? I think it's likely that we're going to see a fresh wave of insolvency across the UK government supply chain and continued issues with delivery and performance. And to my mind, with the kind of wider geopolitical factors, is going to really bring into focus the need for closer scrutiny of security of supply. For example, we need to ask, do we need greater visibility over our entire supply chain to better anticipate disruption and compliance issues at sub-tier supplier level? And what should we be thinking about in terms of diversification of suppliers? Interestingly, some of these considerations are already brought out in the UK's updated outsourcing playbook that was published in June. And that has a renewed focus on pipelines and market engagement designed to ensure healthy markets over the short, medium and long term, promoting competition and contestability over time, which I think is key. It's got measures looking at protecting supply chain and protecting against costs arising from supplier insolvency. So I think in conclusion, from my perspective, we're going to have to wait and see what's next for supply chains in the UK and across the world, and what steps are needed to protect them. But I think the key lesson from the pandemic is the need for continued focus on security of supply.
Thanks. Sarah.
Great, I think it's up to me. So hi everybody, and thank you to the organizers at KCL and GW for including me in such a great event. My name is Claire Fitzgerald, and I'm a research fellow at the University of Oxford at the Government Outcomes Lab. And my colleague Rory and I today will be talking about contracting for social services in the UK in light of the pandemic. And specifically, we will be touching on what has been happening with cross-sector partnerships that deliver social services like employment support or public health interventions, and are structured using outcomes-based contracts like payment by results or social impact bonds. So talking through the particulars of outcome-based contract is a bit technical, but all you really need to know here is that, as the name suggests, these contracts link payment with the achievement of pre-specified service outcomes. So instead of contracting authorities paying for the number of training sessions provided to a given cohort, they compensate providers on the basis of outcomes like how many individuals become and stay employed. Now, this is an oversimplification of what a payment by results arrangement might look like. But because achieving outcomes inherently takes longer than verifying activities, this delay in payment can cause a need for working capital on the provider side. And in this case, some payment by results arrangements can include an investor. And this kind of tripartite arrangement, called a social impact bond in the UK, but alternatively called pay for success or development impact bonds. But this tripartite arrangement where you have projects that involve a commissioning authority, usually local government in the UK, a service provider, often a charitable entity in the UK, an investor, usually a social investor in the UK, has been actively pursued by UK central government over the past decade on the belief that focusing on outcomes in contracts has the potential to improve services by offering providers enhanced flexibilities at the front line. So the question that Rory and I are trying to tackle here is, well, how have these kinds of deals been doing in light of the pandemic? And what can they tell us about how helpful these kinds of clever contract terms are over the course of a protracted emergency? Now, as a team at the Government Outcomes Lab, we work quite closely with social impact bond projects. And like most public services, the services available in social impact bonds have had to alter service delivery to be socially distanced, to shift to digital provision, and in some instances, pause altogether. But they've also had to rethink, in some cases, the processes in place for authenticating outcomes, for authenticating their payment terms. So evaluations have had to pause, and new metrics have had to be introduced where maybe in-person data capture is no longer possible. So with these service and measurement changes have come some inevitable conversations about how service outcomes are likely to be impacted, and thus potential changes to the payment terms. As we've just heard from Kate and Jane, quite a lot of guidance has been put out by UK central government, and much of this is geared at making sure supply chains stay afloat and ensure service continuity. Now, for commissioning authorities who are overseeing payment by results contracts, that guidance has recommended that they continue to pay providers on the basis of past performance. And as many of the social impact bonds we work with are jointly funded, the outcomes payers are both central and local government. These projects were given the option to switch, to a fixed-based payment on their sort of anticipated medium case outcomes profile. They could pause altogether, or they can continue on payment for outcomes, but all of this for a temporary period. Now, undoubtedly, securing projects amidst the early disruption of the pandemic was the right call here. But the important thing for outcomes-based contracts, like payment by results, like social impact bonds, is that these changes to service delivery and payment terms have real implications for the consistency and underlying logic of contracting for services on the basis of outcomes. So remember, the activities of today generate the outcomes of tomorrow, and investors are theoretically, on the hook for cash flow. So the quick response here, helpful in the early months of the pandemic, has these ripple effects for and on the contractual structure which guides multi-year delivery in these projects. How do we reconcile fixed terms payments now with outcomes payments in the future without massive double counting? What's the risk-bearing role of investors where cash flow is now at least temporarily secured? these are the kinds of questions that these contracts are bringing up in real term and in real time. So with that, I'm going to pass things over to Rory, who'll speak with more authority than I can on where we see issues arising regarding these kinds of contract terms over the life of impact bond projects, and really sort of speaking on what that means relative to the initial promises of contracting for services in this way. So Rory, over to you.
Super, thank you. Am I on okay? Good. Okay, so we are talking about things that very often happen at the local level. We're talking about social services, and we're talking about things that often involve a collaboration, often including a nonprofit service provider, and some kind of performance manager, but and the local government. So there's some kind of collaboration happening. And like the point that others have made, we're also seeing that these contracts at the local level, which have terms like force majeure or act of God clauses, these are not very helpful because they're designed to sort of stop things. You know, if you can't perform, you want to get out of performance. You want to deal with these problems by putting a pause in many ways on the collaboration. And actually, a lot of these parties want to stay involved and collaborate and solve these issues that Claire's mentioned around, you know, the services changing, the measurement changing, the outcomes being harder to achieve, but being perhaps even more important to achieve. And so that's something that we're definitely seeing. I want to try and connect this with wider contracting for social services. Our research is, is growing in this area, and the following are sort of emerging observations and questions, not conclusions. But so why does this matter? We see that, there's a perception, many of you would be aware of this perception, that sort of procurement is stops at the award. Even if it's in sort of doing the market analysis and supply chain analysis, that once you've signed the contract, that somehow that's the end of the procurement story, and many of us know that that's not the case, but others do not appreciate that, and I think that that means that perhaps central government and senior people even at local government sort of don't quite have sight of the value of that collaboration and don't necessarily resource that collaboration to deal with these kinds of responses and needs to flex and change. I think that really matters and will matter increasingly, because as we look at recovery in the sense of, trying to get people back into the workforce and so on, we're going to be seeing an increased number of social service programs, both direct programs where the government is funding like a labor program, but also programs where the public procurement system is used to sort of add social value, whether it's through some, in the UK, there's the Social Value Act, and there's very recently, in just September of this year, sort of an effort to refresh and strengthen the Social Value Act. But, across Europe and the world, we see, strategic procurement and buying social initiatives. And I think these initiatives sort of highlight that tension between the concept that procurement is just about getting to award versus procurement being about the overall buying and contract management and engagement in a collaboration. I think outcomes also highlight that tension. And I recognize also that sort of thinking about a supply chain also highlights that tension. As many people will know here, we're not about running a competition and getting to award. That's not what this is about. There are other things happening, and that collaboration is, is increasingly important, and we're starting to recognize that, I think. I do also want to plug that we have if this stuff is interesting and you're interested in talking about this more, including social value, we have a Procurement of Government Outcomes Club that meets, that will be meeting monthly. It has previously met monthly, and we're starting that up again. So if you're interested in that, please do join us. Thank you.
Thanks very much, Rory. Lindsay?
All right. Hi, everyone. Thank you so much for having us. So I'm here with my colleague, Nicolas Penagos, and we work at an organization called the Open Contracting Partnership. And we're a nonprofit organization that supports partners around the world to transform public procurement. You know, we fundamentally believe that procurement is performance driven and it should be digitized and transparent. And one of the tools that we use to do this is the Open Contracting Data Standard. So what the Open Contracting Data Standard does is it helps us to support partners to publish standardized open data about the planning, award, and implementation of public contracts, which can then be used for monitoring and analysis. And the standard is currently being implemented in more than 30 countries around the world. And when the COVID-19 emergency began earlier this year, it didn't take long to realize how unprepared most procurement systems were to deal with the emergency and the significant concerns that were raised about the potential for abuse and inefficiency and ultimately ineffectiveness, failure of delivery during the pandemic response. So at OCP, we wanted to support researchers to review the COVID-19 procurement in their local context, to find what's not going well and identify actionable recommendations to improve the outcomes of emergency procurement. And with support from HEVOS and other funders, we launched the call in April. We received more than 80 proposals from around the world. We awarded 12 research grants to partners from Argentina, Colombia, Ecuador, Georgia, Guatemala, Kenya, Lithuania, Nigeria, Nepal, Paraguay, the Philippines, and Uruguay. And just yesterday, we published a synthesis report and each of their findings. And in total, the 12 research projects reviewed more than 1.3 million contracts and found really concerning patterns of high prices, big variation, and high usage of multi-purpose firms or firms with no prior experience. And most of the researchers also discovered serious issues with the quality, timeliness, and completeness of publicly available information about the emergency procurement. So I'm going to hand it over to my colleague, Nicolas, to highlight some of the most interesting findings and recommendations.
Thank you, Lindsay. Well, as said, these researchers in 12 countries, they analyzed over 1.3 million contracts. And I'm going to highlight some of the most interesting things we found. So this is empirical evidence of what has been discussed, especially by Gianluigi. Previously, for example, in Guatemala, researchers discovered that without item classification, 62 different descriptions were used for face masks, and that's only related to the data. But even more importantly, in regards to policy, in Guatemala, the prices were up to 8.8 times higher. In Paraguay, also for respirators and ventilators, it was 170% higher than in the past. So it's all around how data can inform, for example, or find evidence about higher prices. In other countries such as Guatemala and Colombia, the use of multi-purpose suppliers. In Colombia, for example, the Anti-Corruption Institute created an index to assess the participation of these multi-purpose firms that one day might sell ventilators and the next one might supply food for kids. So, and they even found that during the pandemic, 30% of current suppliers are those multi-purpose suppliers. And also the use of firms that have even less than 6 months of existence and that were created during the emergency. So for example, in Georgia, 62 contracts, that's 5% of the total value, went to 32 companies that were established just 6 months before the pandemic. Companies that were just created because of the pandemic to sell things to the government. So in terms of recommendations, and this was part of the key aspects of the Action Research Project, is that the researchers were not only devoted to study what has happened, but also to recommend actionable things to government. In terms of recommendation of policy, things that they could do was, again, what we've just discussed about coordination. And this was made really evident in Lithuania, in Ecuador, and Buenos Aires. and how this could reduce price disparity and improve competence. In Guatemala, also a key element was to recommend standardized requirements for key items. And in Uruguay, the establishment of reference prices and suppliers. There are other important aspects that I want to highlight in Nigeria and Philippines around the training and around how to increase the capacity of public officers on public procurement, and especially on open procurement and on making data available, and also on assisting those low capacity procuring entities, especially in the subnational level, on how to effectively procure and take good examples from possibly national level agencies. And second to this, as Lindsay was highlighting, is the data aspect, because we were able to see that those places that had open and standardized data, namely the Open Contract Data Standard, those researchers had a better time analyzing the data. They were really able to go further and deeper in their analysis. Places such as Argentina, Colombia, Ecuador, Paraguay, and Uruguay, where OCDS data is used, they were able to compare items, prices, to compare suppliers and where they were coming from. So even, for example, explore aspects related to beneficial ownership as to who were the suppliers and links among them, or links between suppliers and buyers. So many of the recommendations that we saw relate to improving data quality, the completeness, and even to just tagging which procurements are related to the pandemic, and disclosing more and more fields related to procurements. I hand over again to Lindsay to talk about some next steps.
Thank you so much, Nico. So yeah, as the findings Nico shared has suggested, we've been seeing over this challenging year that open contracting has really helped countries in their response, both in publishing high quality data, such as in Ecuador, Lithuania, and others, as well as helping to engage civil society and journalists to better understand what is happening. So if you're curious to learn more about these research projects, OCP will be hosting 2 community calls in November, one in English and one in Spanish, with the researchers, so they can share their findings and lessons learned with the wider community. Those will be on November 17th and 19th, and I will share the links in the chat for those in case you're interested. And in terms of follow-up, we're also working with the researchers to socialize their findings for local change and impact. And so far in Buenos Aires, the findings and recommendations have been shared with the local government to evaluate if they could be implemented. In Colombia, the research and index has been featured prominently in the media, and even cited by the IMF, the International Monetary Fund, as an example of a good tool to monitor public contracts. In Ecuador, our partners Datalat hosted feedback sessions with the Procurement Authority, specifically to improve the emergency contracts. And TI Lithuania has also been advocating through roundtables with stakeholders, virtual, of course. And finally, we will be announcing a call for proposals for the next round of action research towards the end of this year, looking at how open contracting approaches can support efficient and effective spending during the global recovery from social and economic impacts of COVID-19. So if there's any researchers on this call who want to participate in the next round, please do get in touch, and we can make sure that you are aware when the call for proposals comes out. Thank you very much.
Thanks very much, Lindsay. Mark, over to you.
Excellent. Thank you ever so much. Well, firstly, thank you so much to both organisations for inviting me to speak to this group. It's been fascinating to listen into as much of it as I can, and to hear the perspectives, and a lot of the research and work that's being done really rings true with the experience we've had in the centre of the UK government in trying to deal with the pandemic, and certainly through the procurement lens, some of the experiences we've had in dealing with those and dealing with fraud in those. You'll hear in a bit, I'm a massive fan of international collaboration on this stuff. I think we all face the same challenges and actually we can get better and better at them and much more quickly if we share the challenges we're facing, and both the things we think we're doing pretty well on to deal with that, but also the things we think are not quite going right. So really pleased to be part of this as well. I'm going to go quite broad to start off with. I'm going to talk about fraud in general, and then I'm going to give some examples related to procurement specifically to try and help with the focus of this session. So who am I? My name is Mark Cheeseman. I'm the director of the government's counter fraud function in the United Kingdom, based in the Cabinet Office, which is at the heart of the UK government. So the UK is invested in bringing together a lot of its work on fraud. It all sits in the individual departments still, but we have a coordination point, which is the central team that I sit in, which brings all those people together. So rather than every individual government body trying to work out how it deals with fraud, we try and do it together. And I have a role in both supporting those through things like 2 years ago, we launched the government's counter fraud profession, so a professional structure for those working in fighting fraud and economic crime. But also I have a role in challenging individual agencies and departments where we feel that they are not going as far as they should, perhaps in fighting fraud and finding fraud and irregularity in their systems. So I'm going to talk about the fraud and emergency management, and you've got on the screen there, you've got a screenshot of the publication and a link later on the slide pack, and I do encourage you to have a look at that. That was the product of my personal experience, as well as the pleasure I have in being part of the International Public Sector Fraud Forum. So I in the winter, our UK winter, the Australian summer last year, I went out and did a secondment with the Australian government to set up a similar structure out there as that we have in the UK. And sadly, at that time, the bushfire crisis then also struck over there. And I found myself advising on how to deal with fraud and emergency management. And rather than do that by myself, I brought together the International Public Sector Fraud Forum, which is the Five Eyes countries, leading experts who are fighting fraud in those public administrations, to actually lay out what is the roadmap for how you deal with fraud in a crisis or emergency situation. What are the things you should think of? And drew off the learnings of the Inspector Generals in the US, the departments in the US, Canada, our colleagues in New Zealand, Sears Fraud Office, and obviously our own experience in the UK as well. So really this is the guide is something for public bodies to say, here is what fraud and emergency management looks like, and here is a guide for how you should do it. And I think many of the themes that I'm going to talk to have already been touched on in the conversation so far. First thing to note is that in emergency management situations, the fraud threat goes up significantly. The fraud threat goes up significantly for two reasons. Well, they're kind of linked. But the main one is that responses have to be at pace. And a lot of chat around vaccine procurement and medical procurement has been around this. The response has to be at pace, and where response has to be at pace, the threat increases. That is then allied with the fact that those who want to commit fraud, the organised criminals and the more opportunistic criminals, they know that. So as such, the threat increases because they are more inclined to attack the system because they know things will have to be done at pace, so the opportunity will be there. And one of the questions in the chat was around the new providers and are new providers an issue? So from my point of view, as I sit on the fraud management side, new providers in a pace environment are an absolute challenge because that's a great place for fraudsters to hide, is in setting up a new provider. So it's when you have to do due diligence at that pace, that is really tricky. So basically the guide has 5 principles in it. We always try and stick to 5 principles to try and make it consumable. And the first is the standard thing in any fraud management environment, which is accepting the high risk of fraud. So, I mean, dealing with fraud is pretty straightforward. You accept it, and then you deal with it as a business issue. So you deal with it in a way that's measured. Measure the inputs, measure the outputs. But one of the biggest barriers in public sector fraud is getting that acceptance that fraud actually is an issue and is something and could be happening in the systems and is happening in the systems. And that's inherently quite a tricky issue because fraud is a hidden crime. So those who are trying to do it are inherently trying to hide what they have done, and those who are good at it are pretty good at hiding what they have done. So to do that means you have to look for it. And actually, if you're not looking for it, you don't find it. If you don't find it, that could infer you haven't got a problem, but actually it's more likely to infer that you're not looking for it. So the first principle is accepting the inherently high fraud risk and that you are likely to be attacked. The second then, because you have to recognize that systems have to operate at pace. If we think of PPE procurement and ventilator procurement and things like that, because they have to operate at pace, integrating trained fraud resources into those processes. So not thinking, right, I'll do a fraud risk assessment after or anything like that, actually just getting a trained fraud person in to be part of that process to watch, learn, and be able to guide. Sounds simple, but you know, in the UK, we've only had our counter fraud profession for 2 years. So actually being able to point out who those people are who are actually trained, have the skills, knowledge, and experience to understand a lot of the vagaries of fraud control and how it works was not something you could easily point at. And is still something that for us is a growing area. It's not, you know, we don't have a massive cadre of those people. We have a lot of investigators, but that's a slightly different skill set to the fraud risk management, understanding risk, putting in countermeasures, use of data, all that kind of stuff. The third principle then is recognizing that the priority is to give funding to pay things out quickly in an emergency management context, seeking to put in as many low friction controls as possible. And that's one of the things that fraud people do to try and we don't want to get in the way. If fraud people get in the way, then we're just not going to be listened to. You have to recognize your context. But that leads on to the third, and this has been mentioned, Rory, you mentioned something linked to this, which was around people think that procurement stops at giving the contract often, or there's that perception. And actually, you know, it's not, it doesn't work that way at all. So the fourth principle is around having a plan for targeted post-event assurance to look for loss. So accepting that loss is going to happen, accepting your upfront controls are going to be weaker because of the pace you have to operate at. So therefore putting resources aside and doing activity to look for that loss and to deal with it. And then the final thing, which is a thing that's very much on my mind at the moment, is the fifth principle, is being mindful of the shift from emergency to something that's more business as usual. Because I'd argue we might be getting into that space now. It still feels like a bit of an emergency, still feels like an emergency. But actually we've been doing this stuff for quite a while now. If we carry on behaving like we were right at the start, we will sit with the same risk profile we had right at the start. When is that shift to when actually it's a business as usual process and therefore should be managed in that way, not thought of as an exception? And that's something we grapple with at the moment. So I'm just going to turn that to procurement, if you'll indulge me for a little bit. So I'm going to talk a bit about UK PPE procurement. So that was an area I was involved in, or my teams were involved in, from the centre of the function supporting. That was a very high risk area. We had new suppliers, we had new supply chains, and completely new supply chains, international supply chains as well, very disparate, very high competition, as the chat has been talking about, and you've talked about so far in the seminar, and very high awareness from criminal groups that this was going on and that government was trying to buy PPE very quickly. And you know, this had gone from, well, it wasn't naught because we were buying PPE already, but you get what I mean. It was gone from 10 to 100 in a very short time. And the stakes were high, right? You know, so the stakes were, we either buy PPE or we can't protect the people who are protecting us. So these were big decisions. So what did we learn from a fraud point of view in that? Well, there's two things. Number one was the quick flow of intelligence into procurement itself. So one of the first things that I worked on with my teams was to set up a flow from our National Crime Agency and our police databases. So when we were doing procurement, we could check immediately before we entered into business whether the people were known criminals or whether there was significant intelligence from National Crime Agency from them. Sounds blinking obvious when you say it out loud, doesn't it? But that's actually not a standard process. And it's certainly not a standard process when you're trying to make decisions in 24 hours. So actually, you know, when we're doing that, That was a big thing for us. And as a result of putting those flows in, we stopped payments of £139 million going out to people who were on those worry lists and who were trying to get into the market. So that was really positive. The second one plays on I think it's the second principle, it is. And the second bit that worked really well, I'm not saying it all went perfectly, because by no means it did, and there were plenty of things to learn, was the integration of capability to do reviews. So we found ourselves in a place where we needed to accelerate our due diligence process. So integrating counter-fraud resource to be able to do things like identify, well, how can we do a check to our complete police national computer against the people coming into the supply chain? How can we do checks using the government data? So that was PPE procurement, and a bit of a flavour of what went on there in a very high risk environment. So I just want to finish with four. I've got 4 lessons down here. The fourth one is still a work in progress for how I actually frame it. To be honest, but the first 3, if you'll indulge me, the first 3 I think are pretty solid, and then the fourth one tails off a little bit. So the first one is about how you have the conversation on an accepted higher risk of fraud, and turning that from a conceptual one to a practical one. Because I think it's very easy to have a conceptual conversation that says, we're in an emergency situation, we're trying to procure very quickly, we accept a high risk of fraud. If you turn that around and say, okay, so you're accepting £10 billion going to organised crime, are you? That is a different conversation to a conceptual one of, we're accepting a higher risk of fraud. So how you turn that into a practical conversation rather than a high level conceptual one is a really important lesson learned I took out of it. And I'll be looking to work with the departments and everyone to make sure we're laying that in as we do stuff going forward. The second one is that you have to accept in an emergency management situation that you have to reduce upfront control. We'd like to say, no, controls, you have to reduce it, because controls introduce friction. The less friction there is, the quicker support gets to communities, individuals, businesses who need it really quickly. And it was needed quickly. There's little doubt about that. So accepting that, I think one of the really key things we have learned is how you have better quality data sets sitting in organizations on individuals and businesses that they're doing business with or they're interacting with. Because if you want to make payments quickly, or if you want to engage with someone quickly, you need to rely on data. So what are those key data sets and how do we make them better quality? So if I was sitting in the UK government or the US government or the South African government, what key data sets do I have across the government that I can rely on in an emergency situation? The third lesson is it's not all about criminal justice. So for those of you who aren't aware of the UK context, the pandemic obviously has impacted the capacity in our courts because courts closed during the lockdown. So actually dealing with fraud in procurement and in wider public sector through the criminal justice route is going to be a hard slog with a decent lead time. This is actually about a heavy compliance post-event checking regime with powers to access data, with powers to give sanctions and get the money back. That's where we started. It was how we get the money back. And that's something that I think about a lot there, especially the sanctions side, because from my experience of running fraud things, if a fraudster can try and take money, and if the only impact is if they get found, they don't get the money, that is not much of a deterrent to fraudsters attacking procurement systems, grant systems, benefit systems, whatever they are. So the sanctions bit is pretty key for me there. And the fourth lesson learned is around having access to flexible resource. And I'd certainly think of that in procurement spaces, so our commercial function and things like that. So if we need to ramp up procurement quickly, the easy thing to think about is how we get more commercial people and more contract managers in. Actually, how do you bring alongside that an increase in compliance and assurance resource? And how do you have a flexible, accessible resource that has the right capability there? Training fraud investigators is not quick, 18 months to get to a decent fraud investigator. You can't stand up a fraud investigation team quickly. compliance can be quicker, but it needs to be really well planned and really well thought through. So how do you get access to that flexible resource? And that's the one where I say, that is less developed in my mind, because that's a question, not a lesson learned. So I need to get to an answer to that question somehow. So I think that just very interesting, just to finish, was that the last presentation on open contracting, because we've had a number of discussions about how open you make who you're giving money to during an emergency situation. And certainly we've seen stuff in Australia and New Zealand where they have a very open policy, not just within procurement, but within other areas as well of making it clear who's getting grants, who's getting government payments and stuff like that, for the kind of armchair auditor, that friction to come to the system. So it's not just a system response, it's a wider system response. So I was really interested in that. So it's been a really intense period. I think we are learning an incredible lot through it, which has been a challenge, but a great privilege as well. And we are definitely still learning, I'd say as well. I'd be more than happy to pick up with anyone any more things on that. Thank you very much.
Thank you, Mark. Because we're short on time, I know that Jessica has some questions for you and for the other panelists. I'll turn it over to her and then we'll close out. We're a little bit over time already. I'll beg the indulgence of our audience. We'll try to close out at about 15 minutes before the hour. Again, Mark, thank you for an excellent presentation. Jessica, the floor is yours.
Thanks, Chris, and thanks to all the speakers for joining us today. I'm going to follow quickly with Mark, and thank you as well for joining us. One of the themes that we're hearing about today, and in fact, there's a debate going on in the chat function, is again that tension that you focused on in your discussion between ensuring that we're getting appropriate goods and services, and of course the expediency that's necessary in a pandemic. To me, that's the real tension in all of this. I'm actually working with a student right now at GWL who's doing research in this area for an article on this topic on how to improve these systems and processes to ensure that in future emergencies and /pandemics we have a better system in place. I think we can agree, at the height of the first wave in the United States, we had a situation where Trump would tweet out PPE now in all caps, and in response, the state of New York would just award a contract to the people responding, which of course led to a significant fraud. I think we can agree that that is on the bad end of what you want to do in an emergency as far as vetting is concerned. Of course, as you were describing, if you go too far in the other direction, you gum up the system so much that nobody wants to use it. So there has to be that middle ground. And I hear you on some of these things, but I'm trying to figure out, somebody was explaining the difficulty of doing due diligence. In the United States, often we rely on certifications, front-end certifications from companies, and then deal with them on the back end through fraud prosecutions through our False Claims Act. But what other things are there? We know that larger companies in the United States are expected to have ethics and compliance programs, things that we know statistically reduce those risks of fraud. But we also know that small and mid-sized businesses don't always have those systems in place. Are those the types of things that you're looking for? How do we really come to a concrete solution, or is there no solution when it comes to the balance between expediency and quality goods and services? Mark, that's for you.
Yeah, cool, that's good. So I was just checking. I didn't want to talk for anyone else. That's a very difficult question. I thought there might be a nice lead-in one first. And
what is the meaning of life while you're at it? Thank you.
I think my honest view is that the balance is always going to be a balance. The balance actually comes down to before I did fraud, I was an operations manager, and operations is about pace versus quality. And that balance is always being balanced, and you are always managing your seesaw depending on the demands around your system and stuff like that. So I think it always will be a balance. And when you throw fraud into that, the people on the seesaw, I think I did say jigsaw, people on the seesaw are trying to get around the system and unbalance it as well. So every time you shift it, they're then changing the game. They're moving into another playground to play with something else. So you can tell it's my childcare day, can't you? As I'm thinking of playgrounds. So I think the answer is it's not about the end point. It's about continuing to go on the journey and accepting the risk. Is probably my feel on it. In the pandemic, it was really difficult decisions. Brand new companies with no history. People who weren't necessarily, a lot of them so from a UK perspective, people who weren't in the country. So actually our data on them was very limited. And then decisions on, you could have a certain amount of PPE in a week. So they were quite difficult decisions. So I think I probably come back to my generalizations, which is one, what I spend a lot of my time in is pushing people to accept there will be fraud and there will be loss and people will get through, because the really good fraudsters will think of a way to look like getting through those due diligence checks, whatever they are. But then the need for our end of the system to balance that pace with always looking to introduce a new control and try it and see if that does just push it more in our favor, especially those low friction controls, which are really important in these kind of environments.
Does that answer your question, Jessica, about the meaning of life?
It does. I feel much better now.
Thank you very much. As I said, we have gone over, so we're going to close out there. Thank you, Mark, for an extraordinary job. Thank you to all the panelists for really wonderful presentations. This entire program is going to be available, as I said in the comments before, is going to be available both on the publicprocurementinternational.com page and also through the GW Law Government Procurement Program page on YouTube. With that, I'm going to close out the program. I'm going to shut off the recording, and I'm going to close with a song that is lifting the hearts of everyone around the world, Jerusalem. It was suggested by our colleague Hale. Thank you for that. It started in South Africa and Angola, and our colleague Fred Lees was really crazy about kids. So I'm going to include this the challenge, the TikTok challenge of Jerusalem, performed by kids, I think, in Paris. I hope you enjoy it. Thank you again for joining us today. Bye-bye.
Thank you. Thank you.